thank you all for coming, and we're going to get started today. We have with us today Lisa, Tom, and a new member, Oren. And I'm Carol Zacharias. But before we get started today, I'd like to say thank you very much to Luke. He was the chairman until just recently, and he did such a great job, and we were so fortunate to have his leadership, and I just want to say thank you. I also want to say welcome, Oren. We're excited to have you, and I'm sure you're going to make great contributions, so we're thrilled to death about that. So we're all set with everyone online and the video back in the back of the room there? Yep. Okay, great. Let's go ahead and start. The first case is, I believe it's adjourned. It's the Maximilian Casante case, 484 First Neck.
Yep, so we have a request from the applicant to adjourn that to the June 10th meeting, if the board would like to make a motion.
All right, we don't need to vote on that? We just adjourn, correct?
We do.
We do? All right. Do I have a motion to adjourn?
Yes, a motion.
Second?
Sure.
Aye. All those in
Aye.
favor?
No.
All those opposed? We are adjourned. All right. Second case, also in adjournment, was Eiffel Residence. Alex?
Yep, I believe this was already adjourned to the June 10th at the last meeting.
All right.
And so that will bring us to the next case.
Perfect. All right. So that's the Metamere Partners case, 66. Sorry, wrong. Because I'm sorry, I switched the order on me, so I'm flipping around. GST exempt trust for R Mile, 75 Hetty Creek, correct?
Yes.
Hi, I'm Debbie Croft. I'm the architect for the applicant.
Good evening.
Okay. And so at our last meeting, we were asked to come back and bring a planting plan. This was for the area variance, and the other request had been for the long environmental assessment form, which was submitted today for the wetlands. And those were the two items that
We have.
you have and were requested. And actually, just as far as the trees go, the homeowner has planted the trees already. So that's a photograph
Can we
of
get
the
that
tree.
up on the?
Is it, which way does it go, this way?
Facing you, yep, then we'll pick it up on the overhead screen.
Okay,
Thank you.
all right. And we have some other photos as well that he just took like an hour ago. So those, the neighbor had requested that 3 cryptomeria be planted, 12 to 14 feet in a certain location, and so these cryptomeria are 14 feet high currently. So,
All right.
do you have any questions, or is that?
Anyone have any questions? No?
And the neighbor's okay? The neighbor agreed to this?
Yes, this is what, at the neighbor's request. In fact, he even told the homeowner to purchase 12 to 14-foot cryptomeria because they were less expensive than 16-foot cryptomeria. And they will grow quickly, so.
Absolutely. And they're easy to maintain according to the papers, so that's
Yeah.
a good thing, too. Any comments from anyone in the audience or anyone on Zoom from the public? No? All right. Any other discussions, deliberations? Do we have a motion to approve?
A
So
motion.
for this one,
Oh,
we would
sorry.
close this. public
sorry.
hearing, and then at
Correct.
the next meeting, if Brian and Lisa have enough information, they could draft the written findings and also the wetlands permit that's
I
required.
forgot. Thank you. All right.
So that's
So
a motion to close.
do we have a motion to close?
So moved.
All those in favor? Motion. Matters closed. Thank you.
Okay, thanks.
All right. The next case is the 85. We're going to move 85 down east so we can let our expert go, and rather than wait to the very end. So that's at the end of the agenda. Anyone here from?
Did you want to do 66 Meadowmere or 85?
Oh, excuse me, I skipped over that. Yep, 66 Meadowmere. Thank you.
So this is a new application for a wetlands permit. And Brian, I believe you have the affidavits sit on file.
Ready?
Yes, thank you.
Okay. Jim Walker from InterScience for Meadowmere. This is a simple renewal. This project was approved. I originally drew up plans and got the state approval in 2020. Nothing's changed. Property owner did ask me to go down and take photos. We submitted the photos. And I have a letter of support from the next door neighbor, which we also submitted. Since this is a renewal, I've asked the board how much of a presentation that you want. The plans are exactly the same that were approved prior. We have a current DEC permit. The project arises from a drainage grate that is on the south side of the road and drains into the client's property. The client has a problem with ponding. The drainage ditch gets clogged with leaves and sticks, and it doesn't drain properly, so it becomes a little pond, and it makes a mosquito problem for the property owner, and it stinks. And it's been reviewed by Gary Gillespie when he was still here as the highway superintendent. And I had a letter of support originally, which I submitted again to the village, stating why he would support the project. For the board's information, we are simply restoring the old drainage ditch, getting rid of the excess leaves, branches, so forth and so on, to allow the drainage channel to work properly. And then we're going to remove the common reed, and we're going to remove the Japanese knotweed, and we're going to plant native wetlands species there all along the little ditch.
This is the ditch from Meadowmere to the top of Halsey Neck Pond?
Yeah, but it's a very short distance across the upland portion of the property. That's where the problem is.
Okay.
Gigi Mortimer asked me to take pictures. If you look on the picture to the right, you will see a little pond. In fact, there's a snapping turtle in that little pond. That's where the problem ends up. The water comes in real fast. It scours out a big hole. It leaves a pond where the surface water sits. It rots all the vegetation and turns into a mosquito breeding ground. So basically, we're going to restore the drainage channel the way it's supposed to be, and we're going to plant native wetlands vegetation on either side.
Could you put this so we can see that as well? Thank you.
Thank you, Carol. I was trying to figure out where this ditch is,
Yeah, exactly.
because I have a satellite map, but I couldn't.
So can you walk us through here in terms of where the ditch is on this particular?
If you're driving down the road and you turn from Cooper's Neck Lane onto Meadowmere Lane, and you drive to the end of the Mortimer property, there's a white gate. The white
Yep.
gate is the service entrance for the landscape contractor. Just beyond that, the standard head wall is on the far side of the property, far side of the road, on the south side of Meadowmere Lane, and it drains a lot of water. There's a culvert pipe that goes underneath of it. It connects to an old ditch that's been there for eons. The old ditch is clogged. I can point it out here if you like. It's right here.
Yep. Yeah, that's right.
It's very easy to see if you go there. There is
It's easy
a,
to see on the satellite map, too.
there's a ditch here. That ditch is the excess amount of water coming out of the drainage grate, across the road, down through the Mortimer property, and into Halsey Neck Pond, and it's causing erosion. With the drainage ditch redug to 4-foot effective depth, the water will drain better, and it will get polished by the native wetlands vegetation that the state required that we plant. There's 3 species of plant materials that are required there. They're all native. They are similar to the plants that we put in for the 3 lots when we did a common reed Japanese knotweed management plan approximately 5 years ago. That project was successful, and it works, and the soft rush that's planted along the Mortimer property works really well as the edge of the lawn captures the water that comes off the lawn, and it filters through the dense plantings of soft rush and polishes the water before it reaches Halsey Neck Pond.
Any
That's it.
comments from the,
No, I did see that they updated DEC wetlands permit was just submitted this week, so they do have that updated, so they extended from 2021 now to 2027. I have no issues with the existing permit and the way it's written. I think the conditions, similar to the DEC conditions, would be the standard conditions on this. Out of curiosity, is it envisioned that this would be something that has to be returned to continuously, or is there a sense that this would be established in a way that after it will become naturalized as a drainage area?
All common reed and Japanese knotweed projects require maintenance. Anyone that tells you otherwise is full of it. For instance, we did it at the Mortimer property, and that's been successful. But we also did it at James and Maureen Callanan, immediately across the pond. And it probably took 3 years to kill the Japanese knotweed. We repeatedly dug it up with the permits and removed the plant material, and it works. But Japanese knotweed is a terrible weed, and it's very difficult to control, and yes, it will require some maintenance. Not really similar to the rest of the Mortimer property. This area is just Japanese knotweed and just common reed. It's impossible to walk through. You could try if you like, but I don't think you'll make it unless you have a machete. So
all right.
that's about it.
Lisa, what about the depth? Is that appropriate? 4 feet?
So as this is an older permit that's being renewed, I'm not entirely certain as to how they sized the 4 foot, how they determined that was the appropriate sizing to begin with. But it is consistent with what was previously permitted and what is currently permitted by the DEC. Out of curiosity, was it sized specifically for the amount of water flow?
The state worked with our office considerably, and they required all of it. The side slopes, the 4 foot depths, basically the drainage ditch needs to function. Once it functions, we're going to plant native grasses on the sides. That should help maintain the ditch and also crowd out the Japanese knotweed and the common reed from coming back. So I think the ditch is fine.
Okay.
I think it's properly sized. It's somewhat similar to other projects we did with Gary Gillespie on Cooper's Neck Pond, draining into Halsey Neck Pond, right at Cooper's Beach. It's kind of cut and dried. It's more or less restoring what was there.
Okay. Any other questions, comments? Anyone from the public have any questions on this? No? So adjourn till next time to come back?
Yeah, well, it's up to the board if you feel like you have enough information that you want to close the public hearing, or if you need to if there's any reason to keep the public hearing open for additional information to the next meeting.
I can't imagine keeping it open to the next meeting for other public comments. It's all dictated by the state and so on and so forth. Does anyone have any other thoughts?
Is there anyone in Zoom or the room?
I ask. Anyone else on Zoom? Anyone in the room said no already? No? Okay.
Lisa, if this were closed, would you have enough information to draft a wetlands permit for review by the next meeting?
Yeah, well, so the only thing that hasn't been done yet, and this was just that we were having the line verified by our wetlands inspector, and he was going to go out next week because he was waiting for the vegetation to be a little bit more mature than when we first got the call. So I guess if we wanted to, if I want to reference that existing, the newly delineated confirmed
We'd
line,
wait.
It would be best to leave this open so I could reference that, but you could still direct me to prepare the
Exactly.
the permit,
Right.
And just close and take action next time.
I think that's brilliant.
I did speak to Will, and we did stake the old wetlands line. We recreated the old wetlands line to help Will out.
Okay.
So I think it's pretty straightforward.
Should be straightforward, yeah. All right. so we'll
Okay,
hold
so in
it
that
over.
case, it sounds like, well, we would ask for a motion to adjourn this public
To
hearing
the
to the
next
next meeting,
All right,
which is scheduled for May 22nd.
yeah. Do I have a motion to adjourn to the next meeting? Second? All those in favor?
Right.
All right, we are adjourned to the next meeting.
Thank you.
Thank you. All right, so now we're going to move to the end of the agendas because we want to get our expert out of here, so she doesn't have to wait to the end of the day, in the evening, and that's 85 Down East. All right, so could those folks come forward?
So this actually was a public hearing that was closed on the April 24th meeting.
Right,
And you should have a draft wetlands permit that Lisa prepared to discuss.
when was that permit provided to us?
I believe might have been distributed yesterday or today.
Yeah.
Lisa, you could help summarize?
So,
I can summarize. This was the if you recall, the dock that we had looked at, and we saw them present on it multiple times. The board had the concern that they connect the dock to the existing pathway, which was done in the last presentation. The dock is flow through, so there's plenty of light that will pass through that dock, and the vegetation underneath it will still be able to grow. So the permit was written to permit the construction of the dock with, in accordance with conditions, to make it in accordance with the plans that as they were submitted to the board.
all right. Procedurally, we got this yesterday.
And then you also have a secret determination because it is in the village's code, wetland special permits are actually type 1 actions. Probably should be amended at the Board of Trustees level to change that. But so I did prepare the FEAF parts 2 and 3 with the negative declaration for you to take action on.
Okay,
And we don't have to worry about the coordinated review because all the other permitting is in place. So
Mhm.
there's no other boards to be consulted.
okay. So you all received this yesterday or so? Is everyone comfortable with voting on it today? Or do you want to adjourn to the 22nd so you have an opportunity to read what was submitted and then we can vote on it then? Thoughts, Tom, anybody?
If you haven't read it, I would recommend considering it on the 22nd
That's why
rather
I'm
than today.
asking.
Okay,
Yeah.
perfect.
Hence I'm asking.
I
right?
agree with Brian
All
and
right.
you.
Right, that was my hint.
So
All right.
you don't need to take any further action. We'll just add it to
Yeah.
as a discussion item for the next meeting.
Absolutely. All right. All right. So now we're going on to the area variances, special exemptions, correct? Alex, am I on track? Carryover cases? Oceanside Equities, 575 Hampton Road.
So I don't believe the applicant is here. Our office reached
Right.
out to them today, and they said they may be withdrawing this case, and they would be providing a letter probably tomorrow.
Okay,
So I think for now, we may want to just adjourn this to the next date.
all right, let's do that. No motion necessary, correct?
No, but this is still open, so I'd ask for a motion to adjourn
All
this
right.
to May 22nd.
Motion to adjourn, anyone?
So moved.
All those in favor? Aye. Opposed? All right, it's adjourned. So now we move on to the area variances, new cases, and that is the Cordell case, 39 Moses, John Bennett.
Yep, and this case is reopened by motion of the board.
Hello, John.
Hello, my name is John Bennett. I represent the Cordells. Matthew Cordell is here. Just want to introduce him. Baseball hat, T-shirt. Let me get myself acclimated here. That's awesome. Thank goodness. So, oh, you need the affidavits. This is a reopened and we renoticed, so I think Brian needs to look at the proof of mailing and service.
Linda, I think that's her mic.
Linda, you're rattling the paper on your mic.
Sorry. The mic is touching the paper.
That's usually me.
Or me.
So thank you for voting to reopen the hearing. Candidly, given the stark difference between the board's comments in January and March, I felt it incumbent on the board and the applicant to have further discussion and the benefit of additional information, so thank you very much. I greatly appreciate that. Just to superimpose two very salient facts. The lot size on this property is 14,117 square feet, and our proposed home is 2,906 square feet. And it needs no variance relief whatsoever. This is a house that will conform. We're going to show you that it conforms handily to the neighborhood, but it conforms in all aspects to the various changes in the zoning code. It conforms to the GFA requirements, it conforms to the setbacks, it conforms to the pyramid law, it conforms literally to everything. So why are we here? We're here because of a condition that was imposed 27 years ago in a radically different regulatory setting. And I candidly don't think that there can be any reasonable difference about that. I know that sounds bold and maybe a little arrogant to say. I hope you don't think so. I simply cannot see how this isn't a textbook change circumstances case. And so the record started several months ago, and I'm here to further review the record, particularly in light of the appointment of the new chair and the new board member. So I will go through the record I will try to be quick about it, but it's important to be thorough. At the first public hearing in January, there appeared to be a general consensus among the board members about lifting this covenant. Then Chairman Fran, quote, "I think you have a strong case to say that a denial would represent an undue hardship because they could knock the house down and get what they want anyway," and that was approximately 1.05 on the video from that meeting. And then Board Member Giffra, "I understand that 1998 was a long time ago, and with the current restrictions in place in the village in terms of the GFA and the pyramid and the height and the setbacks and things like that, I think it's probably more a formality than anything else." And then Ms. Zacharias, you said, "This ship has sailed, the world has changed, the code is there are regulations and restrictions to protect the community. I would let this go and remove the covenant." And that was at approximately 1.13. Those comments entirely encapsulated this very straightforward application. They were correct at the time. There was nothing changed to take away these very, very accurate comments. And nothing has changed. So it was with quite a bit of surprise that I saw what I can only describe as an about face to certain aspects of it at the last meeting. My associate was there, and I had gone away quite candidly thinking this is on cruise control. And I think it was entirely appropriate for me to think that. So I was a little bit surprised when I watched the tape. Three things support this application. First, and we'll go through this, there have been enormous changes in the law. We'll go through it item by item. I think I'll foreshadow a little bit, but the changes in this law are so dramatic. It's in the village code since 1998, when this condition was put on, that essentially all of the fears that the Zoning Board of Appeals had at the time have been taken care of by the legislation of the village. It's a totally different ball field, so to speak. Excuse my metaphor. Back in '98, if you think of the village as the pitcher, there was 90 feet between the mound and home plate. Now there's about 45 feet between the mound and home plate. It couldn't be a different playing field. So let me try to get into that, but I have to do it methodically. So we have the 98 condition imposing the prohibition against expansion of the existing residence. That's what it said. And you sort of, in these covenants, you live and die by what they say in there, because the case law says that if there's any interpretation, particularly in land use, where they're supposed to be construed against the municipality, if there's any interpretation that benefits the homeowner, you're mandated to go with that. So it says existing house cannot be changed. And you sort of have to die and live and die by that, which means, as Luke Fran said at the first meeting, since you could knock the whole down house and start again because the covenant prohibits changes to the existing house, it's sort of a hardship. And I agreed with him. I didn't quite understand what it seemed to be his change of mind. It didn't seem to be rational to me at all. Respectfully, but I have to say that. So let's talk about the significant changes. The property is improved by existing residents of 2,276 square feet. We want to construct a second floor addition. We're going to expand by 630 square feet. I wish I was better at eyeballing this stuff, but I'd be surprised if this room is anywhere near that size. But it's all, so the total will be 2,906 square feet, all in conformance with current gross floor area requirements. We did submit floor plans, and you'll see on A1, the existing second floor plan is 465 square feet. The existing first floor is 1,811. If you flip to A2, the first floor is staying the same at 1,811. The second floor will be 630 square feet of additional space. Interestingly, for sort of these things that you look at, no change in bedroom count. The bedroom count of the existing bedroom count is 4. The proposed bedroom count is 4. They'll get bigger, but that's consistent with the fact that this house was built at a time when bedrooms were sometimes quite a bit smaller. So anyway, it's a 4-to-4 bedroom count, so there's no impact on the sort of things that you would look at on any sort of, impact on services, impact on any sort of, any sort of thing that you look at in terms of bedroom count. No impact whatsoever. The residents after the construction of the proposed addition, I'm going to keep on saying this because it's very, very important, will comply with all zoning, every bit of it. Asking for an addition that will comply with zoning. So the proposed home, even once expanded, will not have an impact on the neighborhood. I'm searching for any harm here. I can't find it. I'm a very experienced land use guy, both in litigation and appearing before boards. I know how harm is defined. I don't see how anyone can even start to say there's some sort of harm. And that's what you have to look at, because what you have to balance is any harm to the neighborhood, and we're going to talk about what the neighborhood consists of, and the benefit to the applicant. So let's talk a little bit about how this village code has been overhauled with specific provisions regarding house size, height, pyramid limitation, setbacks, and green space requirements. In 1998, what was the limitation on how big a house could be in the village of Southampton? It was coverage. That's it. That's it. 20% coverage. Which is why we included in both a prior application and prior submissions, and as well as our May 2025, our May 8th submission, what we did was we showed you what could have been built in 1988, and it could have been a 7,000 square foot home, 2.5 stories. That's what could have been constructed on this property in 1998, and maybe that's what gave the zoning board pause. Could be. Could very well be. Although the legislation, we think it was an improper imposition of a condition. Regardless, I'm assuming that's what gave them some pause. 7,000 square foot house on a 14,000 square foot lot, which you could do because it was only lot area. That's the only thing that prohibited you. So again, it is apples and oranges, and that's the whole basis of a request to remove the covenant based upon change of conditions, because the conditions are wildly different as what is now.
But this lot is very small compared to its neighbors,
Nope.
isn't it?
Nope, I'm going to take you right through that.
Okay,
I'm
thank
so
you.
glad,
Sorry.
Tom, that you brought that up. Because you're going to find that of the 10 houses that we studied, we will be the 9th smallest.
Oh.
I'm going to take you through that. I'm glad, because that's very good. So, no restrictions. 2.5 stories could be 2.5 stories, 7,000 square feet. In 2003, and that's Exhibit C to my May 8th letter. In 2000 oh, by the way, I'm very sorry. The limitations that were in effect in 1998 are contained in, I guess that's our Exhibit A. That's our Exhibit A. So I keep all those old books, believe it or not, to see how this stuff comes about. Then in 2003, the village code was amended to include a gross area calculation of 12% of the lot area plus 2,000 feet. And that's in C. That's Exhibit C, but I've laid this all out in my very detailed letter of May 8th with the attachments. So we have 2003. You have 12% of the lot area plus 2,000 square feet. That's the principal residence. That would have allowed a 4,823 square foot house. So that's, what is that? That's 5 years after this condition. Then in 2005, the GFA was reduced from 12% of the lot area. It was now 12% plus 1,500 square feet. So it's coming down. And then in 2015, the maximum permissible height regulations were amended so that they relate to smaller lots in the village. Thus, instead of a 2.5-story 35 maximum height limitation, the maximum permissible height of the residence was reduced to 30 feet. Took away the half-story in these zones. You can have a half-story in the larger zones. Still more to come. In 2017, this is Exhibit E, the gross floor area calculations were further reduced to 10% of the lot area, plus 1,500 square feet. And that brings us to where we are now. So our subject addition, which is going to sit over the footprint of the existing house, is it's 10% plus 1,500 square feet. That's 2,911 square feet. But then in 2024, the gross floor area calculations were once again revisited to modify certain inclusions and exclusions from the calculation, including counting double heights as 2 floors and some other things. So this has been a long journey, a very, very, very contentious at times journey with the village as to how they're going to land on gross floor area and key it into house lot size and do some other things in terms of pyramid restrictions, which were never in the village. The town had them probably 30 years ago, but pyramid restrictions, increased setbacks, taking away half stories, and most important, that keying the house size into the lot size of the lot. So again, now we're at 10% of the home plus 1,500 square feet. Maximum size of this home in this area could only be 30 feet. It used to be 35. Again, this regulatory framework has been radically different, is radically different now from the regulation in effect 27 years ago. So I scratched my head. There was a comment by the then chairman at the March 11, 2025 hearing. I mean, I listen to these things and I try to figure out where people are going. He said, well, isn't your proposed expansion exactly what the ZBA had in mind in trying to prevent? I don't know how they could have had that in mind. It ignores the overhaul of the zoning laws that has gone on since 2003. And not without a little bit of sarcasm, my response to that, yeah, I mean, it could be what they were trying to prevent if they were clairvoyant. If they knew what the change in the laws, this massive change in the laws was going to be. I mean, this is like a textbook change of circumstances, change of law, change of facts case. Just not the same. And then we demonstrated there's a clear change in the circumstances with respect to the development pattern. We had submitted a neighborhood analysis with 10 properties. That was Exhibit G to my letter, but it was a previous submission. It had been previously submitted. And I'll just take you through it quickly because you can read it, but since the adoption of the 1998 decision, 5 of the 10 properties on our neighborhood analysis have been completely redeveloped, I should say. One of the properties was developed for the first time. It was vacant land in 1998. Additions have been constructed on 2 of the properties, and the last property has been improved by additional accessory structures. Not one single of the 10 studies properties remains as it was in 1998. So talk about changed facts. Unquestionable, significant change since the adoption of the condition. The existing residence is the smallest residence of those included within the study. At 2,226 square feet on a parcel that is 14,1117 in size, with the addition of 630 square feet, and this is all in my letter. This would be the 9th smallest of the 10 properties studied. Only 59 Moses is smaller by a mere 200 feet. So. Okay, sorry. For example, well, 59, let's see.
There is no 59 Moses. It's
Okay.
59 Harvest. There's no 59 Moses.
Okay, thank you. I'll just rest on what's in my in my submissions. If that's the case, that's the case. It is what it is, as they say. So, for example, the property E identified in the analysis, which is 57 Moses, has a lot area of 15,057 square feet. In 2015, 57 Moses was developed, and a new 2-story residence of 3,304 square feet in size was constructed on the property. Thus, 57 Moses, although slightly larger by about 900 square feet, was redeveloped with a residence about 400 square feet larger than proposed by the applicant. And then 70 Moses, which is, it just tells a lot of the story. That's property F on our study. Has a lot area of approximately 12,017 square feet, 12,017 square feet, which is 1,400 square feet smaller than Mr. Cordell's property. In 2007, 70 Moses was redeveloped with a new 2-story residence, 3,477 square feet. Thus, 70 Moses is a smaller lot, and it's improved by a residence 1,200 square feet larger than the proposed expanded residence on the applicant's property. Someone at the last hearing had raised a question regarding flag lots. We did include 3 additional flag lots at 48 Harvest, 46 Harvest, 437 Hill Street. 48 Harvest is improved by an existing residence of 4,701 square feet. And that exceeds the current maximum floor area restrictions by over 500 square feet. 56 Harvest is improved by a almost 4,000 square foot property. So since the imposition of the condition in question, there's been significant change in the surrounding neighborhood. And again, I keep on asking this question. I don't feel uncomfortable saying this, but I really challenge anyone to tell me and demonstrate factually where any sort of harm is. A 600 plus or minus square foot addition, same number of bedrooms, sitting on top of the footprint. So the rationale for the imposition of the condition has evaporated. Both from a legal point of view, it's been taken care of by the trustees, and the neighborhood is substantially changed. So I'm here before you asking for a decision that conforms with the prevalent development in the neighborhood. I'll just cite the appellate division in Kim versus Zoning Board of Appeals of Irvington. A denial is likely to be found arbitrary. You have to have something really compelling, such that there's going to be some sort of, environmental issue. And we submitted additional case law that the addition was inappropriate in 1998. Sandy International is a case I litigated here. I went to a board to ask them, this board, to ask them to remove a condition. And some of the board members said, oh, that was just a parking variance. Well, parking drives the house size. Everybody knows that. People come in here, you have to have a certain number of parking spots. So it's not a mere parking variance. What that does is enable people to build a larger house. And the Supreme Court overturned that denial of the removal of the condition, saying it intruded into the area of the building inspector. That's the same that happened here. That's another argument, you understand. My argument is, there are a couple of arguments I have. One is that the condition was inappropriate and should be removed. But even assuming arguendo that the condition was appropriate at the time, which I don't think it was, it should be removed. The ball field is totally different. The concerns that the Zoning Board of Appeals presumably had have been taken care of by legislation. So again, Sandy is important. We also submitted a case that I litigated in the town where they refused to remove a condition. And it's interesting what the Board of Appeals in Suffolk County said in that one. Land should be able to be used in the way a person wants to use it. That's an inherent right. When you have zoning boards and zoning laws, you're intruding on that ability and the inherent right to landowners to use their land as they see fit. So when you do that, you have to do it in a particular fashion, and you can't be arbitrary, capricious, and you can't be illegal about it. You can't be, well, he says corrupt about it. There's no corruption going on. I think it's just perhaps a misunderstanding of what the appropriate standards are. But what it does say is you can't be arbitrary and capricious. And if you're holding me to such a higher standard than the neighborhood and saying, taking a see no evil, hear no evil position on these massive changes in the law, that's arbitrary and capricious. And I would ask you to keep that in mind. Village law section 7-702, which prescribes the powers of the trustees, says you can't enact zoning laws within a district that are different within a district in terms of treating people separately. You can enact different zoning you can act zoning districts. You can have a 3-acre zone, you can have a 1-acre zone, you can have a half-acre zone, but within those zones, you can't discriminate against the restrictions on house sizes, limitations such as that. So why do I bring that up? Because the ZBA can't do something by condition that's not permitted to the trustees. You can't by condition create a condition that the governing body, the trustees, can't do. And you're going to have to just be patient with me for a second. But there's a guy who wrote a book called Purchasing Submission. It's Philip Hamburger. Philip Hamburger is a professor at Columbia Law School. And he also wrote one of my favorite books, and it's called Is Administrative Law Unconstitutional? But Hamburger is a very serious guy. And what he talks about is this rampant tendency for agencies to, by condition, impose things that they really don't have the appropriate power to do. So here you have a situation where the trustees can't say within a zoning district, say here, an R40 or an R20 district, say you can do that in this house, but you can't do this in the same house in the same district. So again, that was an attempt, which is why I think the original condition was illegal. But having said that, that's one part of my argument. But the primary argument, and I think, by the way, that argument is the right one and would prevail. But the primary argument is, even assuming arguendo, the village board, the zoning board of appeals has some reason to impose the condition. That's gone. It's evaporated. And again, I don't see the harm. Then you have a covenant that, by its very terms, applies to the existing home. And Luke Farron caught that very quickly. He said, it says the existing home. You have to live by that. And we have case law saying that that's exactly what you have to live by, including a case that I litigated over in Shelter Island, where it's an interesting case subdivision was created over adjacent to the Ram's Head Inn. And it said all the things that restrict how a house can be built. It had architectural controls, it had setbacks that were more over and more than the zoning setbacks. But one thing it never said was that you couldn't have commercial parking on the property. And the Ram's Head owned a residential lot, but across the street, and we were putting some of the commercial parking over there, and the homeowners association sued on the covenants and said, well, look at all these restrictions on the homes. And my guess is probably that the drafter of the covenants thought, okay, all these covenants relate to a home, so it's implied that the only thing that you can have there is a home, but he or she never said, but you can't have commercial parking there. So the court correctly said it's construed against the owner. One of the things that is very important, and why are we here as much as any reason, it's dollars and cents. So what we did, and again, this economic support and economic evidence is supposed to be considered by the board. That's Wilson versus Town of Mohawk at 668 New York Subsecond 62, and Dunwood versus ZBA of North Hempstead, 207 Westlaw 3000317. That's a Supreme Court, either Suffolk or Nassau case. Tim Davis and Harold Grant have submitted affidavits in support of our application. I think it goes without saying that these are the two, very prominent, very knowledgeable brokers with an enormous integrity. I've worked with both of them. They have incredible knowledge of the Southampton Village market. Both have incredible integrity. Mr. Davis estimates that the property would increase in value by somewhere between $600,000 and $800,000 upon construction of the proposed addition. And Mr. Grant estimates the increase in property value somewhere between $800,000 and $1 million. And respective rental values, they both estimate that the rental value would be increased by 60 to 70 per year upon construction of the proposed addition. That's the benefit. Remember, we're supposed to weigh the benefit. It's a weighing scale, the benefit to the applicant opposed to any sort of detriment. That's the benefit. Candidly, Mr. Cordell is here, and we've had this discussion. His price was paid based upon what he thought could be done with the house. These plans went to the building department, and at the very last minute, Chris said, I think you have an issue with the covenant. It was Mr. Cordell was represented, I give you this just so you can sense the overall sort of equity of the situation. Mr. Cordell was represented by a lawyer. It's no need talking about who it was, but who missed the covenant. Missed the covenant. So they came to me, and they said, what can we do? And I said, let me look at it, looked into the history. I said, I don't think this covenant belongs there anymore. Because the whole rationale for it is gone, evaporated. And that's what we're here for. And again, I know this seems brusque, and some people may think it forceful, but I challenge anyone to demonstrate any harm. And when I say harm, that's a term of art. That's a term of art in the zoning law. You have to demonstrate something other than, I just don't like that. I want it to remain at its existing square footage. You have to see what the benefit is to the applicant, which we've demonstrated in significant ways. What, as opposed to any negative impact on the neighborhood, of which there is none. It's a 4-bedroom house going to a 4-bedroom house, going to be rebuilt to current standards with a mere 600 square foot addition on the second story. Again, I think this condition, even assuming it's not illegal, which I think it is, doesn't bear any relationship or have any nexus to the harm for which it presumably was concerned about, a 7,000 square foot house on a 14,000 square foot property. The Board of Trustees, through years of significant modifications and amendments to the village code, excuse me, bite my tongue. Dr. Corman used to say when somebody would make village. And that's the difference. Elise Corman used to say that. I used to get a lot of fun out of hearing her say that. The significant amendments to the village code, 27 years ago. And I think you guys had it right at the first meeting. Scratching my head as to what went astray. Don't understand it. That's why I'm here. Thank you for opening it. I wanted to give it a further examination. I wanted to present it myself. I wanted to present some economic evidence. I wanted to do a deeper dive into the neighborhood and a deeper dive into the law governing when you are supposed to look at conditions. So, for example, and again, I feel very, very strongly about this, about what the law says. So I'll just read. The second department, this is where we are, said that the applicant seeking modification need only demonstrate the existence of a sufficient reason for amending a condition. I think we've more than adequately demonstrated a sufficient reason. I mean, we've gone well beyond that. And even the case law and covenants, which has to be applied here, a covenant is supposed to be, if the purpose for the restriction has already been accomplished, which again was to keep the size of this house down, then the covenant no longer has any real meaning and effect and should be extinguished. Anybody have any questions?
First, before we get to the board, thank you for that. Appreciate it. Are there any comments by the public before we proceed? Any other comments? Thank you.
Yes, so,
Well, we need you to come up to the podium, otherwise we can't record your comment. Thank you.
I'm Eleanor Dunham. It's Dunham, and I live at, I don't know you guys. Hello. So I live at 59 Harvest, which is listed, I guess, in your work as 59 Moses. So their property, my house was built in the 50s. I'm one of the original type of Southampton houses. So I feel like it would harm me. It's funny to even be speaking because we bought the house in 2008. We downsized from a larger house on Hill Street. And my husband was served on this board for many years. So I wish he were here. He could speak to Mr. Bennett, which I don't know all these details, but I think I have about a 1/4 acre lot, maybe smaller. I don't know which one it is from. It's on your list. He's calling it 59 Moses. But
Okay.
my property, my backyard, is like half or less than half the size, and it abuts their property all the way, my house, my pool, my deck, and it goes all the way to the end of my property. And they're great neighbors, you guys. I love your house. It's beautiful. But for some reason, I thought it was a main house, a pool, and a pool house when it was built. So, but apparently it's 2 complete houses, which I didn't realize. So I feel like it would be an impact on me because it would be right next to my pool, and their pool is right next to my back deck. The main house is on Moses Lane, so I'm already impacted. And if it were to be rented, a rental house, I think it would be like looking over my yard into my yard and my pool. So it's just the typical Southampton story where everything around me has sprung up, and we bought the property. We were downsizing, and I said, "Well, let's put a second floor on." And my husband said, "No, we're downsizing. We want to keep it one story." So ultimately, it will be it's a tear down. But I'd like it to just to kind of maintain the property value of it.
All right,
So
thank you.
what
for
could
that.
be done?
Ms. Dunham, just to clarify, your property is on the south side of Harvest Lane.
Exactly.
And it's
Exactly.
about 1/3 of an acre. There is
1/3.
another property, 45 Moses, that is between your property and the proposed house.
45 Moses.
45, if you were to proceed south from your house, there's a property that's 45 Moses, which is about 0.8 of an acre, that appears to have a house and then structures in the rear. And then this lot is to the south of 45 Moses.
So this doesn't abut, this doesn't?
It does
No.
not.
No.
You're kidding. I'm so sorry.
I didn't understand your description, that's why I was thinking, wait a minute.
Wait, where is your house? You're not on, you're on the.
It's my house. It's on Moses.
Thank you.
Okay, Alex is gonna.
This is your property?
Yes.
This is the subject property that they're asking.
Oh, I'm so sorry.
No. I'm glad you spoke up and now it's clarified.
Thank you.
This is a
Thank
good night
so
for
much.
you.
Yes, exactly.
Speaking.
So well, good to meet you. Then you're apparently not my neighbor.
No, they're nice people.
That's right. All right. Is there anyone else in the audience here that would like to speak up? Yeah? And then we'll go to Zoom.
First of all, I'm sorry that I started this whole thing, because I wanted my niece and nephew to move into the village.
You have to identify yourself.
Oh, I'm sorry. I'm Jerry Rosengarten, and my wife Paula and I have lived here for the last 26 years or so. Right. And when this house became available, it was like godsend at this stage to have them be able to move into that house. So of course I told them to do it. And they had plans with what they wanted to do, not grand plans, just to keep a nice house in the village. And then all of a sudden, this thing came up about a covenant. We had no idea about it. They were represented by an attorney. It's just going to cause nothing but havoc. And now we've been here 6 months, going through, trying to start to renovate, because the house is not livable now. The house is not livable. And we're not going up, we're not going out. We're designing it within the framework of the foundation. So, that's all. I had to get up and say this.
Thank you for speaking, and I'm hoping that we can resolve this for everyone. Thank you.
Thank you.
Anyone else here? Is there anyone on the Zoom? No? All right. Well, let's then close down the public comments and turn it on over to the board for reopening discussions. Any thoughts and comments? Linda?
I have a question.
Sure. Linda, just pull the microphone over. Thank you.
Trying not to wrestle. This says it's the existing east elevation, which looks like a 1.5-story house.
The existing east elevation, yes, it's a 1.5-story house. You'll see on sheet number, hold on a second, let me get there. The existing floor plans are shown, that's probably the best way to look at it. Linda, hold on a second. The existing floor plan, I had it, hold on, it's here. Sorry about that. Let me get there. The existing floor plan is sheet A1. It's the second one in. I think it's the second one, A1, and you'll see that there's a bedroom up there, and the existing floor area is 465 square feet. And then the first floor plan is 1,811. If you flip the page, the proposed first floor plan is going to be rearranged, but not picking up any square footage there. And on the second floor, picking up the additional 630 square feet.
So this is the proposed elevation of the east side? So we're going from 1.5 stories to 2.5?
2, yes, no.
No, two.
No.
It's 1.5
To two.
stories to
To
2.
2, okay.
Yeah.
When you said it wasn't livable, or it's not livable right now, can you elaborate? I just want to understand what you mean by not livable.
It's a tear down.
It's a tear down? It's the state that it's in?
Well, I don't want to say it's a tear down. The house is going to be totally gut renoed, in effect, but we're keeping the guts and putting a second story addition on. So we're trying to work, because we're trying to be sensitive as possible to work within that footprint. And again, as I don't have to tell you, as tends to be a little bit pricier to do that as opposed to just, sorry, but I don't want to misrepresent anything. We're reworking the existing house.
we're gonna use everything that we can just to cost save it.
You want to come up and identify yourself because you're testifying in effect now. That's okay. I'm not trying to run the board, Carol. I'm sorry.
Hi, Matt Cordell, the homeowner.
Yeah.
So we're gonna try to keep everything that we can possibly keep. Exterior walls on the first floor. We obviously have to remove the roof in the half story and add the second story.
Okay.
So, thanks.
But again, trying to keep it all within that footprint. So I don't, it's hard, it's an extra 600 and something square feet. Hard to imagine any impact.
Comments, questions, thoughts? I've got one question. It's
Sure.
more on the legal side, I
Yeah.
must confess.
Well, I would hope
Surprise,
so.
surprise, right?
I would hope so.
I hear your concern that the zoning laws frankly outstripped the need
Mhm.
for this covenant,
Mhm.
which was there to create some size
Mhm.
regulations. I get that.
Mhm.
And I hear your concern that the zoning laws effectively are a change in circumstance. They
Mhm.
absorb the need and all that sort of
Yes.
thing, and create a sufficient reason. But I want to ask you one question about something you mentioned,
Mhm.
just to explore it.
Mhm.
You said that you cannot do something by condition that you cannot do by law.
Mhm.
And then you continued and you said, not to put you on the spot, but just the gist of it
That's okay, that's
was,
fine. I love the, actually,
Right.
this is one of my favorite.
therefore, you
discussions.
cannot impose a covenant on one property,
Mhm.
just one property in a zoning
Well, it's
district.
two. They did two. They were on, the other was on the other.
two.
Yeah.
But you mentioned one, that this, his property.
Yeah.
That does not similarly apply to the other properties in that district. So I hear you, but I have to ask, are you saying that a zoning board cannot impose, therefore, restrictions when granting a variance?
It's the case is St. Ange versus Donovan, and it talks at length. It's a Court of Appeals case. And in that case, not really factually similar. What happened in that case was they tried to impose a restriction. They said, I think it was a gas station or something like that. We'll let you expand it, but only as long as you own it. So the Court of Appeals said that's an improper restriction. But it does talk about. the
What I'm
ability-
asking is, when can you apply a restriction to one house in a zoning district?
It would have to have a
Stick.
very substantial nexus to some sort of harm that you were trying to affect.
And when
I
that
don't-
harm goes away,
When that harm goes
one
away,
could
it's
go
gone.
and
It's gone.
make this appeal.
Yeah.
Okay.
Yeah. So again, my argument is that even assuming arguendo, the condition that was legally imposed, which I don't think it was, the reason for it has disappeared. It's evaporated. Both factually, the neighborhood, and legally, because it's, again, it's a tortured analogy, but it's really no different than, if the village is the pitcher, in 1998, you were pitching 90 feet from home plate. Now you're like 45 feet. So maybe you don't even have that microsecond that the batter has to react. You have to read his mind. And again, I say this, I've been a proud practitioner before this board since 1982. And I really pride myself on not bringing cases that aren't reasonable cases. People come into my office and they say, I want to do this, and I say, I'm not going to represent you. You're not going to get that. Because this board has a long tradition of being reasonable, respectful, fair, and consistent. And that's all you can ask from a board. But I don't bring these cases unless I think that they're well-structured and deserve to be approved. I don't know how else to say it. I
Right.
wouldn't do that. I don't want to waste anybody's time.
Any other comments from the board, questions, deliberations, concerns? No?
I have one question,
Sure.
just to be 100% clear.
Uh-huh.
If they scraped this house and built a new one,
Uh-huh.
that restriction
Oh,
from
it goes away.
before goes
Right.
away?
Yeah, so
I
that's-
just wanted to be clear.
it says the existing house. I
got
will tell you that I don't know that the drafter of the covenant had necessarily that in mind. I'll be very honest with you. But the law on interpretation of covenants is extremely tight as it relates to, particularly when you involve a municipality. If there's any way to construe it.
I don't want to go back into history, but I recall reading the opinion where they created this restriction. If you go back and look at it,
Yeah.
I believe, I'm hesitant to say this, but I believe the board was inclined not to be terribly excited about it because we were taking a property, we were splitting it in half and
Yep.
allowing to build, and they were not inclined, and they went away, and the owners came and said, I'll tell you what,
Right.
why don't we agree not to build? So this really emanated from them. So I think they drafted this thing to it, the spec of the owner, which may not have been the best thing, but that's how it came to pass.
I always call
That's
offers
all.
like that. Sure, I'll do it for you.
For whatever reason, I'm just saying, if we're trying to fight through the reasoning
Okay.
behind it, it simply was a deal offered by the owners.
Yeah.
But let's talk about today.
Remember
Let's
what
talk
happened,
about
though.
these people
Remember
and
what
their
happened.
house.
It was called a paper subdivision. We call it a paper subdivision in the trade. There was one lot that had 2 houses on it. It's always been my position, and it's been the position of most municipalities, and it's the position of the building inspector, that when you separate that situation, so to give each house its own lot, you are decreasing or eliminating a nonconformity. Because in the village of Southampton, 2 houses on one lot is deemed to be a nonconforming use. So when you divide it, even if the lots are somewhat under the current zoning, you may have nonconforming dimensional lots, but you have now eliminated a nonconforming use. That's why we do these things called paper subdivisions. Because, before 57 in the town and 30 in the village, you could have 2 houses on one lot.
All right, so let's try to get forward here. So do we have any other comments or questions from the board? No questions or comments? All right. Do we have a consensus to proceed to the next? Brian, what are your thoughts on how best to proceed?
No, I just
It's a
wanted
procedural.
I just wanted to clarify a couple of things, because I don't think they're part of the record as presented.
Thank you.
The lot area for this lot is 14,117 square feet. The minimum lot area in this district would be 20,000 square feet.
Right, these are
Of course,
small lots, which
the
is what
variance
led
is
to the original
right. The one in the
restriction.
front is 12,200 square feet.
Yeah.
All part of a variance that was granted by this board back in 1998. So they're permitted. The front yard setback for this lot is 28.5 feet, where the minimum is 30 feet. Again, by virtue of the 1998 approval, the board authorized that setback, authorized the lot areas, authorized the flagpole lot, with the conditions that they imposed, for which the applicant is now seeking relief. When you're comparing the neighborhood for this particular property, part of your consideration should be relative to the nature of the development here, where you have a flag lot, you have a property and a house behind an existing house. And part of your comparison and consideration should be in relation to other properties that are similar, representative of the neighborhood. So I just want to point out that from what was submitted in Exhibit G, I think just one of those lots that was presented is reflective of a property separation, such as the applicant's property. That's all I wanted to know.
All right.
Let me respond to that, if I may. The village has very specific flag lot requirements. And if you were to create a new flag lot now, that would have specific requirements. And we dealt with this on the case that you guys were kind enough to grant recently for Deborah Hurst. But it's important that you understand that those sections are in the subdivision regulations. The village code defines lot area as the total horizontal area of a lot, exclusive of land in the bed of any street. And then it talks about maximum gross floor area of a dwelling within all the residential codes as being 10% of the lot area. These are terms of art. 10% of lot area plus 1,500 square feet. So candidly, I don't see how, and lawyers, Brian's a seasoned fine land use lawyer, but we can have differences about this. If the village had decided by what they put in their zoning code as opposed to their subdivision regulations that they wanted to exclude the area, the lot area from the GFA calculation, it would have been very easy for them to do, but they didn't. So again, the code just defines the total area of a lot as the total horizontal area of the lot exclusive of the land in the bed of a street. It says or waterway as well, but that's not what we're dealing with here. And so you don't take that out of the GFA calculation. And flag lots, again, I sort of scratched my head. There's flag lots all over the place. There are some, in effect, flag lots, or even less than flag lots, multiple lots that that are serviced by a private right-of-way all over the village, including on First Neck Lane and South Main Street. So a flag lot, there's been all sorts of flag lot development in the village. I don't see that as an ill or a harm. Makamoto, for example, which has a flag lot. I'm sorry, the driveway to probably 4 or 5 houses is the fee down to the Makamoto piece, and it's that fee ownership down to Makamoto is also used via right-of-way by 3 or 4 homes. And they don't even have the benefit of having a flagpole, which at least that's fee access. Just, you've got 4, 5, 6 lots sometimes. Fairly, that's all right-of-ways. Fairly is not a road. It's a road by definition in the village code, but that is a road that's comprised of right-of-ways. So there's only the corner lots have legal access on the Gin. Thank you. So there's been all sorts of development using flag lots and private right-of-ways, and I don't see that as all it's an ill. And again, they don't take that lot area out of the computation of the GFA. If you, again, I'm trying to be absolutely transparent across the board and everything as I always do, because I have to live and die by what my legal understandings are. If you were creating something, a new subdivision, and you wanted to have flag lots, they would have to comply with certain standards in the subdivision regulations, which are a separate chapter of the code. Anyway, that's my response. I respect Brian's
Just to be clear, in terms of it being a flag lot, I wasn't referencing a flag lot itself, but you have 2 houses back to back that are deficient in lot area. Use that as a consideration when you're looking at characteristics.
I would say probably 75 to 80% of the homes in the village of Southampton are deficient in lot area. If you go from Gin Lane, Little Plains Road, Gin Lane, South Main Street, in that entire quadrant up to where the R40 zone starts, that's all, I'm not talking about the south side of Gin, which has big lots on the ocean, but the north side of Gin, because the board has granted relief for, to me, on twice in that area for lots that were 2 acres as opposed to 3 acres. If you go from Gin Lane and then Little Plains Road on one side, South Main Street on the other side, go all the way up, taking all that 3-acre zone, there's not one conforming 3-acre lot. So I promise you that, because I've done the analysis. It's actually in the record of one of 2 separate variance applications that were granted here. There are more non-conforming lots in the village of Southampton by far than there are conforming lots. So just because it's a non-conforming lot. I don't see that as a negative. Certainly very consistent with the pattern of development.
Okay. I don't know that we have a consensus, but shall we try? If we have a consensus, we could then have Brian prepare an opinion for next week. If we do not have a consensus, what do? We adjourn and we continue deliberations next time? Alex, how do we proceed with that?
Just procedurally, right now, the hearing is open.
Right.
So you can close it,
Yep.
and then you have a certain amount of time, 62 days,
62
to make a
days.
decision.
Right.
Well, I'd like to hear the thinking of the board. I think that's typically, in the
I'm
40
not-
years I've been doing this, that's what I've understood.
Let's see if we
Yeah.
have a thinking
Okay.
of the board.
Yeah, okay,
We're
thank
trying to
you. Thank you.
figure this out. So.
So you can close it and deliberate, you can keep it open and deliberate,
Okay,
whichever direction you want to go.
all right. Any thoughts on which way we want to proceed in terms of open and close?
Let's close it and deliberate,
I
so we
agree.
don't have to do the other
I
stuff.
agree. I think we've heard
Yes.
I take it we've heard everything.
If I may,
Oh.
the long tradition of appearing before this board, and I take great difference with Mr. Wallach and Mr. Stoller. It has been the long tradition of this board, in the years that I have been representing people before this board, 1982, to have the applicant have the benefit of the sense of the board while the meeting is open. And what that does is allow me to inform my client. It also allows me to respond to certain elements of the deliberation that you may have. Why wouldn't you have the applicant have the ability to hear what you board members, who are going to make the decision, are thinking?
All right, I hear you. How would we like to proceed? Do we want to open it and continue to deliberate next time, or close it and deliberate next time, and they would not have the opportunity to make comments? Any thoughts on that, anybody? Anyone feel
I'm
strongly?
happy to close it. I think we've heard everything we can learn.
That's not my point. My point is,
I understand your point.
My
I
point
do
is you
speak
may
the English
have-
language,
it,
and I'm not getting paid by the billable hour, and you've taken 90 minutes now.
well, okay, Tom, I don't think that's a fair comment. I really don't. I don't think that's a fair comment.
Okay.
We're trying to
Can-
close it so we can go on to the next step, and you keep talking.
I understand
I don't view that as an effective use of anybody in this room's time.
What I was merely saying is, in my long tradition of appearing before this board, typically deliberations happen when the meeting is open, so that I have the benefit of commenting on some of the thoughts that the board member may have. I may be able to further elucidate, or may be able to give further information based upon questions, concerns, comments that the board may have. I'm simply asking for
Okay,
that.
so,
Can I make a suggestion, just because we received this rather large document in the last day or two?
Yeah.
And it's something I'm sure the board has not had an opportunity to fully grasp what is being said there. If there are comments that the board may have, or considerations that the board wants to address as part of the hearing,
Just keep it open.
based on that, rather than take action tonight to close, continue the hearing to the next meeting, and at the next meeting, you can then have a chance in advance to review the documents. If there's additional information, we can ask. You can state that the information on the record, whatever it may be, but in that way, you can utilize everything that's before you and essentially consider everything that you need to get to an end result, regardless of whether you ultimately deliberate during or after you close.
That makes
Yes.
sense.
Thank you.
all right.
Thank
Well
you.
said,
Can I
thank
hear a
you.
motion to adjourn to the next meeting?
Second.
Any?
Aye.
Thank you very much.
All right.
All right, thank you, and thank you, Brian. Moving on. All right. Diamond Communications, correct, Alex?
Yep,
Diamond?
I believe that's the next case up. This is
Alright.
a new public hearing, and I believe we have the affidavits of mailing and posting in order. So we should be okay to continue this hearing. We should also have, on the dais, a report from Lisa, a staff report. This is a special exception request for a public utility structure, and it also includes certain area variances pertaining to setbacks and retaining walls.
All right. Welcome.
Thank you. Good evening, Madam Chair and members of the board. Robert Corioso with the law firm of Snyder & Snyder on behalf of Diamond Communications.
My name is Thomas Van Esky, also from Diamond Communications.
All right. Proceed.
Thank you. This is an application at 25 Windmill Lane, which is the fire department property. It's for a communications facility, and it's proposed for the equipment for the village's emergency services at this point in time. Just by way of background, so you understand how we came about to be here this evening, the village, recognizing the need for better communications, particularly for the police, the fire, and the EMS, issued a request for proposal to improve the communications in the village. After an exhaustive review of the bids, in June of 2024, Diamond was selected as the winning bidder. And thereafter, Diamond looked at 40 different alternative village-owned properties, performed a comprehensive analysis of the radio frequency coverage in and around the village, and ultimately, at the end of last year, the village board issued a lease to Diamond Communications for this piece of property because it is owned by the village. However, we're going through the zoning process. We've already appeared before the planning board for site plan approval. They've declared their intention to be lead agency. We've appeared before the ARB, and now, or I should say the BAR, and now we're in front of you for the special permit and various variances. What the variances are for the setback of the tower, because the setback has to be the height of the tower. The tower is 125 feet in height, plus a 9-foot lightning rod on top, so call it 134 feet. So the tower does not meet the setback on 3 different sides. Also,
Wait, that's the pyramid or the setback?
No, that's a unique requirement specific for towers.
Oh, okay, sorry.
also the existing property right now in the back of the property where the facility is proposed, there's a large slope. In front of the slope is a building that'll be removed and a burn pit that'll be removed. They basically form somewhat of a retaining wall in that area. So we're proposing to remove that and build a new retaining wall, and it'll be fenced and landscaped. So because of that, the retaining wall technically has to be 20 feet from the property line, and it doesn't meet that setback on a number of the sides. And also, a retaining wall is supposed to only change the grade by 3 feet. We're not changing the grade, but because the retaining wall is approximately 8 feet in height, we need a retaining wall height variance as well. So those are the variances and the special permit. What we have here is the site plan. You have it in your package, but we also did a number of visual renderings that you should have in your package. We did coverage maps both for the emergency service equipment, the Motorola equipment for the village, and we showed you how also the service would be improved throughout the village for the wireless carriers that hopefully in the future will co-locate here. We submitted a structural report to show that the tower would meet all of the structural standards and would actually have a fall zone on the property, so that's why we believe the setback variance is appropriate. As far as the site plan, we showed the detail. Both the ARB and Planning Board wanted some additional details because of the secret process. I completely understand that tonight's the initial meeting with your board, so we will be updating the plan to show the additional details of the ground equipment, the compound, fencing, and the retaining wall, and you should have that by the next meeting. But we'd be happy to answer any questions you may have this evening.
A couple questions.
Sure.
First of all, can you put up on the screen the color depiction of that was in the submission of what it will look like, the fencing and the spot where the tower actually would be and so on? I'm trying to grab it myself so I can show you what I mean. I think that's very illustrative.
On the plans?
Yeah, yes.
Okay.
Yeah.
So we have a couple of different drawings. I think
This-
it's
this type.
C2.
This-
Oh, okay. The cover sheet? That would be
It's
This one?
I
overall
have it.
parcel plan.
CO.
Yeah, okay. We'll start with that.
Yes.
and then I'd like to go to the C2 after that.
Okay.
Okay?
So this is the, you want me to walk you through it, or do you have questions first?
No, you just go ahead.
Sure.
Take
So-
your so you're the expert.
This would be Windmill Lane here. You have the firehouse here. This is the parking lot for the movie theater, just to give you a reference point. The facility's in the back here,
Right.
where the existing building is and the burn pit is located. Well behind the
So
existing
you're
building.
west of the fire department.
Right, between
Yes.
that and the movie theater parking lot.
Gotcha.
Now could you
Yes.
go to the next one, just to show them C2, because this is like a zoom in on it, if you
Yes.
will.
So
There we go.
the fire department building is here. Right here.
And the movie
I'm
theater
sorry,
parking
right-
lot is.
right here.
And show them
The movie theater parking lot is up here.
Up there, yeah.
This is the back property line. This here is the retaining wall that will replace the existing building and the burn pit that are in this location here.
And that is a chain link fence around it to the left, right, and on the bottom there, correct?
Correct. So right now, we have a proposed chain link fence with slats,
Mm-hmm.
8 feet. I believe in our next iteration, we're going to try and lower the fence on the top of the wall.
Right,
And then we have a landscaping plan on another sheet that shows the landscaping around the edges.
right, trees and so on. So it's a retaining wall in the back, which is how tall?
It's approximately 8 feet.
8-foot retaining wall back there, then a U-shaped chain link fence with a large gate, a rolling gate on the
Correct.
lower right.
Yes.
Right, so that's the picture. Now, show them where the actual tower would be
The
located.
tower would be located here.
Mm-hmm,
And what we have is the equipment area for the village equipment.
mm-hmm,
And then we've designed the tower and the compound for future space for the wireless carriers to be able to put their equipment, so that way there's not a proliferation of new locations, that they'll be able to co-locate here and be able to provide service through the
What would
village.
that, I couldn't grasp the materials, I'm sorry, I'm not an expert at this.
Sure.
What would the other equipment be? Would it be tall? Would it
No,
be
so they're
short? Is it a
typically,
bunch of trucks or
so they're
something?
typically equipment cabinets. Back 10 years ago, they would be equipment buildings, similar to the
Okay.
building that's there now.
That's what I was
The-
worried about.
The equipment has
You would
shrunk.
call those server racks today. It's a bunch of servers in a rack.
Yes, and
structure.
they're in standalone cabinets that look like the size of small refrigerators.
Okay, okay. Now, that tower is 134,
125 feet to the top
But
with a
the-
9-foot lightning rod.
okay. And can you explain to, I went to another meeting, so I have information, I just wanted to be sure they had it. Can you explain to them, or Alex perhaps, the normal falling
Sure.
distance
So-
required and what we're going to get?
Sure, so the code requires the height of the tower, which I guess could be interpreted as 125 feet or 134 feet. We put it down as 134 feet, even though that's to the top of the lightning rod. The towers are galvanized steel. They are not designed, or they don't just fall over like a tree would fall over. What they typically do is the metal would deflect and it would crinkle on itself. And what we've done is we've submitted a letter, and we've shown on the plans a radius of 21 feet. So the tower will be designed to stay within that crinkle zone on the property, which is the distance, a little less than the distance to the closest property line.
Okay,
And as you mentioned at the planning board, it's overbuilt so that it is designed not to do that.
Correct. So when you look at the letter, there's a national standard for these types of towers, and this tower is designed to be 25% above that
right,
standard.
it meets the standard plus,
Correct.
right.
Do you have a picture of the tower?
So what we did is visual renderings. It's in your package. If you'd like me to try and pull it up, it's 8.5 by 11 inch. Do you have that handy, or you want me to take that
Why
out?
don't you go ahead and put that up and flip into it?
Here it
But
is.
It's C5,
Well, so
I think.
we also did visual renderings, but let me start with C5.
That's C5.
And then and then L1 is the landscaping, by the way, right after that.
Sure. So
One second. It looks
How
like
high
that.
is the retaining wall now?
It's
You're
down here,
raising
it's-
it.
about the same height.
There you go.
Oh, I
That's
thought
it.
you said you were.
We're not increasing. It's just,
Page is one.
we played it safe with how we noticed the hearing,
Right.
that the way the code reads is you cannot increase the grade by more than 3 feet with a retaining wall,
Right.
which I think is a little wonky to try and figure out what that means. What we're doing is we're replacing the building and the burn pit, which is in essence the retaining wall, and we're putting the retaining wall in the same spot, but we're not raising the grade by any way.
Okay, I
It's
get
still that same 8-foot slope in the back. So this would be, if you could see, this would be the tower. The top of the tower is the 125 feet, and the lightning rod, which is just that thin rod barely visible on top.
Where's the firehouse, just to give us perspective?
Sure,
Where
so
would
the firehouse, if I'm getting this right, I believe the firehouse would be over on this side. So this would be looking towards the back.
But how low would it be? For example, looking at the
So
retaining wall. and
here's the
with
base,
trees.
here's the base, which
Right.
is even with the firehouse. The
Right.
firehouse would be in this location.
Correct.
And Windmill Lane would be over here.
What I'm asking is, how high up that pole is the roof of the firehouse?
Oh, gosh.
Level with the trees, for example?
I think it's much higher than that. I think, so this is not to scale, so.
Oh, never mind.
We'll
Okay.
submit something new to scale.
Okay.
This is not to scale, so I don't even want to give you
All
a
right.
feel for that. But when you're looking in, you'll have the retaining wall, you have the fence, and you'll have the landscaping around the back. But
I-
we'll do a better drawing of that.
I think what will help people and get their confidence up is if they could see, well, if I'm walking down Windmill Lane
Sure.
and I look over at my beautiful village, how much of that am I going to see towering
Sure.
over me?
Yeah.
I'm
So
hoping it
we'll,
won't be that bad.
we'll also provide some additional visual renderings where we take a photograph and we use computer modeling to show what it looks like both at the base and the
Right.
tower. And there are photographs already in your package that show that, and you can see the tower is, it's a very, that's the benefit of the monopole. It's a very narrow
Narrow.
dimensioned structure
Right.
as opposed to a building or something large. So your question about the pyramid was a good question, and that's why there's a special tower height requirement, because it's a different type of structure. So, but
Okay.
we'll detail that a little better. But just to give you a feel, the only antennas are actually the two whip antennas on top of the pole for the emergency services. This is just a future potential build-out of companies like AT&T or Verizon or T-Mobile to be able to improve the cellular service. But what we're focused on now are the village's emergency service antennas.
So that's the Motorola antennas on
Correct.
this picture.
Correct.
Will you be able to see this tower from the parking lot behind the theater?
You will.
Oh, yeah.
You will.
So your foliage and landscaping can't
It's too
alleviate?
tall.
Not at that height.
Obviously.
Not at that height.
Not at the total
No.
height.
No.
Would you be able to see this from the other side, the non-fire station side of Windmill Lane? Like, say, Shippies or Rotations?
So the base will be mostly behind the
The fire station?
fire station, but
But
and the
it's gonna be
tower will
taller
be
than
off
the
to the
roof.
left, but it will be taller. But if you look at the fire station, there's a number of things on top of the roof. So it's a fairly tall building, a number of things on top of the roof.
Alex, do you know how tall the fire station is?
I could only estimate.
Because the taller it is, the less
you-
intrusive.
Could you put, yeah, you're right where I am. Could you put this up on that in the
can,
next
I can.
slide? Because that's really what they're asking.
Stories, this is 125 feet, so this is
12
like 12
stories.
and a half stories.
Yeah.
The next,
Like a very big
It's-
building.
The one thing we don't ever call it stories, just because a story is, very specific to a building because of the density and the bulk. But we do reference it as height. And let me show you what the visual rendering looks like, because I think that's an important part of our application. And we're going to supplement this based on some comments of the other boards. So for example, this is a location from the Main Street parking lot. And here you can see the light poles and the buildings in the foreground. That would be the tower in the back under the full build-out scenario.
Yeah.
But you can see how that is in the background there.
and then can you show them the next page?
Sure.
I'm not pushing, I just want to help them out.
Yeah, so,
And there it is.
again, here you have, from the flagpole location, so you can see the flagpole in the foreground, the power lines, and then the towers in the background, and that would be the firehouse down in there. And these are in your package.
Oh, here's the tower, yeah. It's hard to miss.
I'd like to see it like when you're standing at Shippies and you're walking by the bakery and all that sort of thing. So these are very helpful, but I look forward to seeing the others as
Sure.
well. That'd be great.
I mean,
Ultimately,
this
when you have-
goes to our concern about undesirable change to the neighborhood.
Yes, and
Sorry to interrupt.
this is one of those situations where, it's infrastructure, and it's critical infrastructure.
But it's in a commercial location. I mean, well, sorry, we'll deliberate, I'll be quiet. for
It's
now.
in a commercial location.
I mean,
It's on a,
it
it's
is
on
what it
a,
is.
you know, a use that's already there as a firehouse. It's customary to have equipment like this on firehouses. It's outside of the historic district, which we
Right.
think is important. We did look at 40 different locations, and there is a technical aspect to this. We submitted the coverage maps, and at this height, at this location, it can cover the village, which was very important.
Oh, so you need that height so the police.
Correct. Yes.
So there's no way to make this shorter.
No, because then it would not cover the full village.
And
So
I-
the
I-
guys who rent from you for cell coverage will have smaller envelopes because
Not
they're lower.
necessarily. They use different frequency ranges, and they have other sites that do provide some service into the area, so it's all a jigsaw puzzle for them.
This is
and-
not a great area for cell coverage in
Well,
the
the other,
summer.
the other thing, and you said a very important point, you used the word coverage, and that's part of it. When I said it'll cover the whole village at this height. As you know, come Memorial Day and more year-round, there's more capacity. There are more people. They're doing more things since COVID in particular. So there's the coverage, but there's also how much can each site handle? And that's a very important function, and that's why there are new sites needed.
When you're looking at the poll,
Yes.
and let's say you're getting max providers, everyone to tie in, and I understand that you're having these racks, or you're providing this area down below. Will the pole structure change with everything fed through, or do you
So
do that?
what we showed, it's a good question. So what we showed on C5 was that full build-out.
Yeah, if it was full.
So if you look, we're showing the, and I don't know if you can see this, the top section where it says elevation 120, proposed Motorola antennas,
There you
that's
go.
the
It's up
municipal service.
Right.
And then we showed 4 different levels of antennas
Mm-hmm.
for the wireless carriers. Here, here, and here.
Okay.
So that would be the worst
Wait,
case.
three
And we
wireless-
showed
That
that,
would be max.
that would be max.
That's worst case.
Worst case
And we
scenario.
showed that in the visual rendering as well. Yes.
Any other comments from you? Because I'd like to move on then to the fire department and so on. I understand that they may be here as well. So,
Yes.
Anything,
Thank
other
you.
comments? This has
No.
been very helpful introduction. I do
Thank you.
appreciate it. Thank you.
But before they leave, I just have one question. Did you submit, and I was just looking through everything, I didn't see it yet, did you submit an RF emission report
We did.
and showing compliance,
Yeah.
I would assume?
Yes.
Okay,
The
thank you.
safety, for health and safety, it's in there.
Yes,
Yeah,
yes, it's in
there. Thank you.
definitely. Thank you. Comments from anyone here? Police department and others? Fire department? No? Oh, I heard a rumor they were coming. All right,
They're here, but I understand there are folks here, but
okay.
I think the village board underwent a very lengthy discussion on all those issues, and I think
Okay.
it's well understood what the need is.
So just to share it with the board, from what I understand, and Alex, you were at the meeting as well, that it's very hard in the summer for police, fire, and ambulance to communicate with each other. Just like we can't communicate with each other. Hence, this need is really one of safety and welfare, not just our convenience for talking to each other.
That's right.
I just want to throw that
Yeah,
out there.
that's correct.
It's very important.
This currently doesn't envision our convenience. You have to find tenants for those other 3 layers.
It's the old saying, if you build it, they will come.
Okay, fair enough.
Works in the movies.
Do we have anyone on the Zoom that would like to make any comments? Anybody? No? No? Okay. Any other comments from the board?
Very thorough
Yeah.
submission. Thank you for that.
Very
Sorry.
interesting.
It's okay. It's going to produce rental revenue as well, right? I mean,
For the village,
for the
correct?
village, correct?
Yes.
Okay.
Yes.
All right.
So, Madam Chair, as I mentioned earlier, there is a process. It's my understanding the planning board will, if you consent, and the ARB, or the BAR, I understand, same, the planning board will be the lead agency. They must make a secret determination before you could act. We have some additional things to submit at their request. So I think, if Alex will agree with me, I think this could be adjourned, but it would have to be after the planning board makes its secret determination.
Yeah, I think that's right. You have in your packet a coordination letter that I sent out on
Yes,
behalf of the
I've read
planning
that.
board,
Yep.
indicating that it's their intent to be the lead agency.
Right.
If this board has no objection to that, it'd be helpful if you could, we'd note that for the record, so that we can let the planning board know that they're going to take charge of the coordinated SECR review.
Okay.
That just means that this board doesn't have to do their own SECR findings, but
Okay.
all of the requests that are made today are still, of course, within the purview of this board.
So if we indicate our consent to have them take the lead board position or review responsibilities,
Yeah.
would this ever come back to us?
So this will
Correct.
continue to come back to this for the special exception and for all the variances that were discussed.
But when they're done, correct?
So those requests.
At what time would it come back to us?
So the board can adjourn this because you have to address all of those points
Right.
that they're requesting. You couldn't approve this until you have a secret determination.
Right.
And that would come from the planning board.
And do
As
we-
assuming you consent to them being the lead agency and do that coordinated review.
So if we consent to them to being the lead agency, do we table this completely until we know that they have given the secret approval, if you will, and it comes back to us, or do we proceed apace?
It's up to you. If you
Okay.
wanted to adjourn the hearing to the next meeting, the secret determination may not be ready yet, but you could possibly review any additional materials that you've asked for. So that might be one reason to do that. And I know Lisa has prepared a memo, which, happy to go over now, or we can continue to go over at the next meeting.
Lisa?
Yeah, I would just add a few things. First of all, I actually think that, you could in theory make your decision before you have the planning board's decision because you're deferring the agency to them and you'll be held by their decision. But that said, the planning board has asked for some additional information that might still be worthwhile, so probably adjourning until they have time to get that would make sense. The memo, this is interesting, like the village code is quite specific when it comes to tier 3 wireless facilities, and they require a specific staff memo that addresses particular points. So this is a bit of a duplicate of the memo I prepared for the planning board that specifically addresses all those things that are required to be in the staff memo according to the code. I would just point out that at the bottom of that memo, if you when you do get a chance to look at it, that I did try to call out the specific things that they're asking the zoning board for, including the special exception permit. And many of the criteria, unfortunately the code's not tremendously clear about this, but the criteria really outlined in the tier 3 code seem most appropriate as special exception standards. So those are really the criteria, the ones that are broken down in the code are the appropriate ones for you to consider. Is a placement of this facility appropriate? Has it conformed to the requirements of, the public safety and the concerns there? And the memo does address those to the extent that I have answers for them. So and in terms of the location, I would just highlight a couple of things. There is a photo in that staff memo that shows the historic districts of Southampton. And as you probably are well aware, the village of Southampton has a huge historic district that covers most of the village. So it's very difficult to stay outside of that and be in the downtown, and this location is actually outside of the historic district, while being in that downtown, which is really centrally located and where it is most appropriate to put a wireless structure so that it can reach everywhere, and also because it'll be less intrusive than in residential communities, presumably. The other thing I would point out with regards to the they've already addressed this, but the height variances that they reference, it's not totally clear in the code, but presumably the logic of the height setbacks is to prevent the structure from falling onto, within the length of its height. And I think it has been addressed by the structural memo that that's not a likely scenario here by any means, that if this were to be a catastrophic failure with incredible winds beyond anything we've ever seen, it would most likely fall. It would fall onto itself as opposed to being toppled over. So that just in terms of the rationale there. And the other thing is that the second, because there were sort of two groups of variances, one related to the height, and so there were 3 different ones because it doesn't meet the setbacks in any of those directions. And the second set of variances all related to retaining walls, which those are both because of the amount of a grade change, but as they mentioned, there is some existing grade change there to begin with the existing building that's in place, as well as the setbacks. And I think that this retaining wall code was likely developed in reference to residential properties where there would have been there is the space to provide these kinds of setbacks. In the commercial area downtown, it's not really feasible to have a 20-foot setback for retaining wall and have the retaining wall at any place in the property. You'd probably require it. So there are just some factors to consider in terms of what these variances actually relate to, because I know it seems like a lot, 6 variances seems like a lot, but they are really just related to kind of 2 areas, the height and the retaining walls, and it's just that it applies to multiple property lines and then the extent of the height of the retaining wall. Yeah, and other than that, I think that the walking through the criteria will be helpful for you. In the special exceptions section of the code, there is no specific set of criteria for utility uses, which is what this is, but the criteria under the Tier 3 wireless facilities provides a little bit more detail.
And I can confirm what Lisa said. In terms of the retaining wall code, that's a relatively new section of the zoning ordinance. It was adopted within the past 3 years, primarily, I think, intended to address residential properties being regraded, particularly about FEMA flood heights and things like that. There's some provisions about how to accommodate septic systems when you're raising the elevation for groundwater. Obviously, that's not applicable here because it's a utility structure rather than a residential property.
What is the expected timing? When are they seeking to complete this project?
Well, we would love, to have it done as soon as possible.
Right.
There are 3 boards. We ultimately have to be able to get a building permit, and then we have to construct it. So certainly before the fall would be ideal.
To start construction?
Correct.
Oh, so to have it ready for summer of '26?
Absolutely. Yeah. And if Madam Chair, if I just give you some timing, I believe we're back in front of the planning board on June 2nd. I think we would be wasting your time and our time to come back at the next meeting, but I think if we can come back after the June 2nd meeting,
10th.
that feels like the right time frame from our perspective.
Okay, but do I have this right, everybody? First, we can defer to we'll all vote on this, obviously, but defer to the planning board as the lead board.
Lead agency for
Lead
secret, yes.
agency for secret. Second, we've got to review the special exception criteria that everyone wants to go through. Third, review the Tier 3 criteria that you just mentioned. Next, review your memo in detail. I've read it.
Which also will outline the Tier 3
Right,
criteria.
I read it, but I need to go back, obviously. I'd like to see the mock-up that you're going to be doing, with the
Yes.
computer-generated thing, because everyone, that's key to variances. And then, of course, deliberate and discuss the height and the setback variances, the 6 that go into those 2 buckets, if you will, correct?
Yeah, that sounds right.
So if we defer today, or consent to them as the lead agency for SACRA, and then should we revisit this at the next meeting, which is coming up on May 22nd, just to talk amongst ourselves and start to absorb all this information. We need to get our graduate degree in electrical engineering here. And then you all come back on June 10 and we have an intelligent discussion. Or should we just wait until June 10? Just adjourn it till June 10 to discuss, receive more information, and then proceed from there, which would be more productive.
June 10 sounds more efficient,
More efficient, I agree.
because then we'll have more information.
Yeah.
And we'd like to be here when you discuss it, because I think this
It would be
conversation's
helpful.
been excellent, so.
We need your answers,
Yeah.
your teaching,
Sure.
so, especially you as well. All right, so it sounds like we want to consent and adjourn to June 10th. Is that the bottom line here today?
Yeah, and it sounds like there was no other public comment for tonight? Just
And
wanted
no
to
one
make
was
sure.
on Zoom.
Okay.
Oh, one person.
What
We
are the other sites that's being considered for?
we need you to
forward
come
to
to
the
the podium
microphone
and
here.
introduce yourself. Thank
There's
you.
2 other sites, right, Alex?
I'm sorry?
He's asking what other sites, but you'll say.
Oh, yeah, so you can address the
My name
board.
is Joseph, and I live at 130 Cooper's Farm. Where exactly are the other sites that has been considered for the tower?
Alex, based on the meeting we had, there's 3 towers that are actually going up,
So,
correct?
no, there's 2 towers that already exist in
They
the
already
village.
exist, okay.
But I'll defer to the applicant to discuss the analysis they did for
Yeah.
other potential sites.
That's a
Sure,
good
so-
question.
So we looked at essentially every village property, and just to run through them, obviously the firehouse, the police headquarters, the basketball courts, Chamber of Commerce, Village Hall, the Green Belt off Cooper's Farm, Wall Street parking lot, Historical Museum, ambulance station, Presbyterian Church parking lot, 25 Job's Lane, West Main Street parking lot, the Vets Hall, the O'Connell parking lot, the Nugent Street corner, on and on and on, Agawam Park, the dog park, the Green Belt off White Street, Cooper's Beach, Olive Pond Lane, Dune Beach, Pistol Range. We can submit the whole list. It was part of the RFP process
But those are
and the leasing
what you
process.
considered.
That's what we considered, correct. All the different
That's
alternatives.
what, those are the sites they considered.
Yes.
And they've landed, this is the best location. But what I wanted to share with him is there are 2 other towers that are being put, or that exist. And between those 2 towers and this tower, we should all get the proper emergency staff support and so on. And the others are across the canal near Dockers, and one is up by North Sea. Am I correct?
Is that right?
the-
Yeah, I think that's right.
This, yeah,
This
Right.
is the only one in the village.
that's right.
One's in West Hampton, the one by Dockers, isn't it?
It's technically town of Southampton.
Right. But it's
Yeah.
kind of
It's not
Hampton
really
Bays,
Dockers.
it's not
I think
us.
it's closer to Sundays and Oakland's, correct?
Oh, okay.
Yeah, so it's,
Oh,
it's
Oakland's.
further down where the commercial dock is.
So is that what you want to know, where the towers are going to
Yeah,
be?
yes.
Yeah. The other 2 towers are over by Dockers or what have you in that area. One is going to be up near the North Sea Transfer Station, or already is, up where
Yeah,
the
I
dump
see
is.
that, yeah.
And this is the one in the village. So between the one further west, the one further north, and ours, we end up electronically covering the region. Does that answer your question?
Yes, and I have one more.
Please.
And if I may, I understand that we can confirm it that South Fork is using Starlink for their EMT and fire department. That should avoid the tower.
I've heard Motorola. I don't know. Motorola, right?
That I'm not familiar with.
Anybody know here? I don't know the answer to that. I'm sorry.
We can confirm it for next time if you want to, or maybe look it up. I think they're.
He's saying that we don't need a tower because they use Starlink, and you don't need a tower for that, he says.
Who uses Starlink?
The emergency services teams.
Who? Which ones?
North Fork.
Who?
North Fork.
Oh,
North
no, in
Fork.
the North Fork, they use Starlink.
Oh,
Yeah.
the North Fork, sorry.
Yeah.
I-
All right.
I
And,
suspect they're not replacing every communications with Starlink. There's numerous reasons. You still need terrestrial-based systems to be able to provide the service and capacity with very low latency on the ground in the area.
I want to make sure did you hear that?
Yeah, I would love to see what they have, and to the extent they may or may not be using it.
Maybe a backup.
Yeah, sometimes
They're
it's a
not
backup
confident
in
that
remote
Starlink is the
areas.
only thing they're using because it may be inadequate and you need something, he said, that is terrestrial, that is on the ground. So it may not be the only thing they use in the North Fork to get the coverage they need. He's guessing.
Well, we can find that out
Yeah, okay.
for
That'd be great.
the board to
Come back.
consider.
Talk to us,
Yes,
yes.
yeah.
Yeah. And you can submit letters and they can respond,
Okay.
okay?
Thank you.
There you go.
Thank you.
Thank you so much. So we are adjourned till June 10. Do
So
we-
what I
Need a
might.
motion?
Oh, no, sorry.
Yeah, I
First
might
we have
suggest
to
is you make a
defer.
motion to allow the
Accept-
planning board
yes.
to serve as lead agency for SEQRA.
SECRA, absolutely. Do I have a motion for that?
So moved.
Second? All those in favor?
Aye.
Yep, and then it sounds like there was consensus to keep the hearing open and adjourn it to the
June
June
10th.
10th meeting.
Right. Do we have a motion to adjourn to the
So
June
moved.
10 meeting? Second? All those in favor?
Aye.
Thank you for your time this
Thank you
evening.
very much.
We'll
Thank
see you in
you.
June.
That was a
Very
very
much.
thorough presentation.
Fascinating.
Thank you.
All right. We have our cell tower project on the way.
Thank you. Have a good night.
Fascinating. All right,
Okay, so I think that's our last public hearing
right.
for the evening.
And now we're on to
And we just have a couple of,
decisions.
yes, we just have a couple of items on work session for the board to discuss.
Right. So we have 3 decisions to discuss, but 30 County Road 39A.
Yes.
Just
so-
received this, so we're thinking that we want to address it at the next meeting so people can have a chance to read the opinion, all things considered, and I don't think anyone would be damaged by waiting until then. Brian, what do you think?
It's up to the board. If you're not comfortable adopting a decision tonight, don't.
Yeah. Did you-
I'm in favor of what she just said, giving us time.
Are you okay with waiting to vote next time on the decision drafted by Brian and delivered yesterday or so for 30 County Road 39A?
Yes, very good idea.
Okay, all right.
Do you need a motion, Brian?
No.
or we-
No,
Okay,
just
so
deliberate the next
I
time.
think we all agree.
Yes, we do. Okay, and then Shippies. Let's leave that for a second. Southampton Partners 85 down, oh no, we already talked about that. So.
Yep, that, we're going to continue the
Yes.
deliberation
Yep.
at the next meeting. And
Exactly.
you have in
Right.
your packet that the drafts prepared by Lisa.
So we only
The-
have Shippies then to
Yep,
discuss.
the only other items are, there's two items of correspondence.
Well-
One is a monitoring report that's tied to a previous application.
What do you want to do about, should we do Shippies now?
Oh,
or-
up to you, you could do that now.
Let's go ahead and talk about the Shippies now. So, new person, lot going on with Shippies,
Yep.
a lot of materials. Shall we also adjourn that to the next meeting, so you have a chance to digest the materials, because this is an important case?
I agree.
Or do you want to dive in?
If it's a question, I feel comfortable with, I spent most of my time on Shippies because it was so, there's so much here.
Yeah.
But if everyone wants to give us some more time, we can,
I don't think we need more time.
No,
I'm okay.
We were concerned about you, Frank.
No, I'm fine.
I would rather read the opinion.
Oh, we definitely.
Which we only
don't have an
got-
opinion yet, correct?
No, the only thing you'll be doing tonight is deliberating, get a sense as to whether you have a majority in one way or
Oh,
the other,
okay.
Right.
and then direct
Sorry.
me
Because we're
to
basically
draft a
short on.
determination.
All right.
Right.
So let's proceed to do that to see if we can reach a consensus so that we can have. a-
If I can, before you can, just want to make sure, Mr. Glick, so you've spent a lot of time on this, you've become familiar with the application, you read the test, you
I
you
do
observed the
have a couple
testimony, you read the
questions about
documents.
it. Yeah, I do have a
Okay.
couple questions from where we left off. So we're at we're at split, or how did it end? 3-2?
The discussion was essentially there were three in favor of one position, and it appeared to be three who would deny the application and two in favor.
Well, just to clarify, not to deny the application, but to approve all but two of the various.
Right, okay,
requests, yeah.
that's right.
Right.
Right, so having to do with the outdoor dining, correct, thank you.
Dining with
So-
it came down to the
Bar
number of
and
seats,
seats.
number
Bar.
of seats and bar. Yeah,
And the,
I
the existence
Correct.
of the bar. Yeah, I think those were the only two items that there
Right,
appeared
everything
to
else
be.
was everyone agreed upon, and it felt we can go forward.
That is correct.
Okay.
And it's
Exactly.
split 2-2 at this point regarding the outdoor seating volume as well as this service bar. And now we have to deliberate that.
Okay, so.
Do you want to wait, or do you want
no,
to jump in?
I feel I'm ready to jump in.
You're ready. All
I
right.
am. And I feel strongly that the additional seating, and I so appreciate what has been done at Shippies and what they intend to do and the integrity of how they built things, and I feel that the additional seating is fine, and I don't have any strong objection to what they're asking for.
Okay.
So,
All right. You've done your homework.
I have done my homework, and I went on site, and I just want to see, I can just envision what they want to do there, and I also know what's going on, and living out here and seeing what's like away from the busy time, and how quiet that street is, and what Shippies brings to the table. So I appreciate the investment, and I see how it was changed, and I think that they're going to continue that, and the parking structure that they're providing is sufficient, and I think it's going to be an enhancement to what's going on that street.
All
So
right.
that's how I feel.
Well set. All right, well reasoned.
All right, based on that, I think we have three in one direction. I will draft a decision for the board's consideration at the May 22 meeting. Just so you know, I'm going away tomorrow for graduation in Nebraska. I won't be back till Sunday, so
Congratulations.
it's possible I won't have it out until Monday, but if I do, be on the lookout for it and be ready.
We will. And all the best for the graduation. That's wonderful.
That's great.
All right.
Thank you.
That's Shippey's, so we're.
Yep, and then that one, the planning board also took lead agency and they adopted a negative declaration pursuant to SECRA. So this board doesn't have to do anything for environmental review. We'll just note that in the draft decision. But the
Okay.
planning board already took care of that.
Do we need to make a motion to adjourn it to the next meeting?
No, it's already closed,
It's
so
already
you could just
closed, it's
continue,
there.
you'll continue the deliberation at the next meeting by reviewing the decision
Okay.
that Brian will prepare.
Great. So that's done with that. All right. Next are the correspondence you were referring to.
Yes, so there's 2 items of correspondence. One is a monitoring report. So this was an application that may predate everybody on the board for wetlands. One of the requirements was that they provide annual monitoring of the planting
Right.
that they do.
We've seen those before.
Yep, exactly. So this is how they're showing they're compliant with that condition.
Where is that report?
It should have been in your packet.
I didn't get it.
Okay, if not, we'll make sure that you get it. They did drop off a couple of copies, and we'll make sure it's on the Dropbox
Okay.
as well. It doesn't require any action on this
Okay.
board, it's just really an update, but
Okay,
we'll make
good.
sure you get it.
And the memo for 36 Windmill Lane, I didn't see that either, May 5th.
Oh, okay, that was just a memo from the Architectural Review Board about Chippies
Oh,
noting.
I saw that.
Yes.
Yes.
Yeah, noting that
A
they didn't have.
one-pager saying,
Yeah, exactly.
"Go
They're
forth."
leaving their hearing open because I think they're allowing for the possibility that this board will have to make a determination, and that might affect their final plans.
Right,
But letting you know that architecturally, they're satisfied with the revisions thus far.
right. All right.
And then also on the agenda, there's a note about the 2025 meeting schedule. So I distributed a draft. We don't have to do this now, but it would be helpful if we can set the calendar, at least going forward into the fall.
So some of us have been talking amongst ourselves, one-on-one.
Mhm.
We would really like to get this, you guys, to a Thursday or a day a week cadence, so we don't jump Tuesdays and Thursdays, because it's hard to get people and get people's attention. So apparently Alex can explain it better than I, but Thursday is a day which is an option for us. The other days of the week are taken by other boards, safe to say.
Yeah.
So what do you all think about meeting on these dates through the rest of the year on Thursdays? Every other Thursday, rather, I should say.
So no more Tuesdays.
No more Tuesdays, is what you and I were talking about
Yep.
at the meeting upstairs with the council.
So we're only going to meet once a month?
Twice.
Twice, but Thursdays.
Okay.
Two.
Oh, so I have to look at, wait, June says, I have the
So in
wrong,
other words, what you're saying is
I have the
that
wrong
Every other
thing.
instead of Tuesday would have been,
It says Tuesday,
meeting on the
Thursday.
15th.
Yeah,
This
something
will be
like that.
starting in
Right.
July,
Okay.
It's
right?
every other Thursday.
Starting.
But July says Tuesday, July 8th.
Oh,
So this is the schedule
As
we
is.
prepared
oh,
at the
wait a
beginning
minute.
of the
I
year.
thought we were switching it over.
Yeah,
Sorry.
so
Can we switch it over to the Thursday? Because otherwise, it's so
So
hard to
Thursday,
get it.
July
I apologize.
10th.
I'd be happy to. We just have to confirm that everybody is available.
Could you do that?
Yeah.
Brian, could you do Thursdays? Because we're just having such a hard time getting.
The second Thursday
one.
is fine. Second Thursday, I'm always available. Last Thursday is usually a problem, but I split myself
No,
in
I think
half
she
and have somebody
wants
else
the
cover
first-
another place.
I think she wants July 10th and July 24th, right?
Well, I don't care. Which Thursdays can you, we need to
The second
alternate.
second Thursday is almost always good.
But the fourth is not, so could do
Fourth,
first and third,
it's-
for example.
Well, it's third and fourth that are usually, first and second are always good. Second, third and
But we need
fourth.
to we can't do it every week.
Right, I
We
know,
need to space
absolutely,
it out.
absolutely.
So what should we do?
So if you're gonna continue with the
It's-
2 meetings a month,
Mhm.
and
Yes.
for a while, we only needed 1, but if you wanted to continue to do 2,
It would have to be
then
the,
leave it this way, and I'll have somebody cover the other meeting.
Okay.
It would have to be the first and third because the trustees have the second Thursday.
Okay.
Okay.
Can you do first and third, or one of those and have someone cover the other kind of thing, Brian? How does that work for you?
Either way, whichever it is, whether it's the third or the fourth,
Okay.
I'll split it
It'll
with
be one
my
and one.
my colleague.
So why don't we switch to the first and third, so it's consistent? We know when it is, people can plan their time, or plan not to be here and let me know, right?
Wait, starting when?
Starting when? I say ASAP.
Do you want to start? We'll start that with the July meetings.
Yeah, you can't do June because we already adjourned to June 10th.
I already noticed.
So July.
Okay, July.
Okay, so I can have a new schedule drafted up, and then I'll have that for you to look at the meeting next week.
Great.
But do you want to meet on July 3rd?
No. Well, I'll be out here, actually.
We all will.
But I don't think anybody's going to want to come and
Well, we
present.
could take a look at the schedule at the next
Right.
meeting and see if there's any particular dates that might fall on
On
holidays.
odd days, and
As
we'll
it
kind
is
of
now,
infill.
Yeah,
that's
neither
true.
one of our November dates work, so we'll
Yeah,
have
we're
to
not
make
going
some
to be meeting on
adjustments.
Thursday, December 25th, I don't think.
Right.
We're 25th?
It's just- Or Thursday, November, yeah, Thanksgiving. All right, we'll adjust for the holidays.
Okay, but in the meantime, I'll prepare a new draft based on the first and third
That would be
Thursdays.
great. So I'll make a note of that. First and third. That would be a big step forward. Thursdays. Okay.
And then the only other item I think I have here on the agenda is there's two upcoming cases that
Yes.
we gave to you a little bit early just as a preview.
Yep.
So those are both advertised for a public hearing at the May 22nd meeting. So the hearings aren't open yet, but you have the information online
Okay.
and in your
Santa
packets.
Morrow and Meadow, those are the two?
Yep, that's right.
Yeah.
Santa Mara at Potato Field Lane. That's a front yard variance for a
A
porch.
porch.
And then the second case is a little bit more involved. It's the Meadow Club of Southampton, where that is a non-conforming use as a commercial use that exists in a residential zone. So because they're expanding some commercial buildings, that requires relief. They're also right on the water body, so there's some wetlands permits
Wetlands.
there as well. So wanted to give that to you a little bit early so you'd have an opportunity to review and take a look. And the applicants will be here at the next meeting to present.
So I'll just mention to everyone, has anyone had a chance to look at it yet? Because we just got it.
I did.
Yeah, I did too.
Yeah.
There's a lot being requested in terms of the variances, so read up because it's going to be
Alex, we're not
detailed.
allowed, can we talk about this without them here? Right, or we should?
Yeah,
No.
This is a public
No.
meeting.
We can't, right?
No, the hearing has not started,
Oh,
so
I
you
see.
should not be,
Started.
yeah, you shouldn't be debating. I mean, you could,
I'm just saying, do you
the
read
gen,
what's on
exactly.
there?
No, you're fine. What you said was fine, but if we start to get into the details, we have to wait till the hearing.
Yep, and I'll mention on the Potato Field Lane case, there was a prior variance case, and that's in the packet
Yes.
as well. For
Which was granted.
was granted for a smaller porch, and now they're asking for a larger porch.
So they never built the smaller porch?
That's correct.
Oh, I get it. I thought that sounded familiar. So same story, just bigger.
That's the
Longer.
request. Yeah, longer.
Longer, not, longer,
Same
but
setback.
not. Same setback, exact, same variance requested,
Oh,
5.5 feet.
The
Just longer porch going
Yeah.
Right.
along the house of the front yard. You'll see. It's not complicated. I don't want to say more because I don't want to get in trouble. Brian and Alex will yell at me.
But just in case there's any code questions or anything that comes up,
I
but
just-
you have all that's
It's
available.
amazing that I was gonna bring it up, and I will not get in there, but the Starlink conversation that's, I can't, I'm so impressed that this gentleman came up and spoke about it, because,
Yes.
I do a lot of bandwidth work at home here on Bowden Square, and I cannot rely on the services that we have in the village, right? There's a lot of dropping. Starlink is my filler, and quite frankly, it has been very reliable, and the bandwidths are significant. So, I thought it was
Well, I've
fascinating to
gotta
bring
get
up. Yeah,
Starlink's great.
is incredible. It's incredible. So, I'm glad that this gentleman, spoke up.
Interesting.
Would we be responsible for deciding whether Starlink would be more appropriate than
That's not
than
before
a
us.
tower?
That's not before us.
That's not before us. No, I just think it's
Yeah.
That's not
fascinating.
before us.
I mean,
You have to
you-
decide
you
what
would
are
not
you
have a
approving what's
tower.
before
You
you.
would need a tower, essentially.
Who would make that decision?
Board of trustees and the committee,
Board of
right,
Trustees?
Alex?
Yeah, I mean,
Did
the,
they consider
They have a committee that was looking into it.
Yes,
yeah, the
just
planning
discuss.
commission has been researching this issue for lack of service and for a long time, and working with the board of trustees. They did a request for proposal on how to solve the issue, and ultimately, this was the proposal that they felt was the most appropriate.
And they had
Was
reps from the
Starlink
fire
considered?
department.
I don't know the specific details, and perhaps the commission could explain that at the next meeting.
They could, but I would throw out there, they mentioned to us that representatives from fire department, police, and the ambulance department were on that committee. I would think they would have raised their hand and said, I'm good with Starlink.
I don't know,
You know.
because Starlink, the growth and their bandwidth has grown immensely over the last
Oh.
year. So
Oh.
if, by the time it gets to
Maybe
the
off the
layman or
radar.
yeah, it's off the radar. It's still new, but the direction that it's going is
It's huge.
huge.
So he raised a really good point.
He really did.
Who can we ask about that? Planning board?
Pop, you could, the planning commission might have some more information about that, because I know they've been working on this issue for a while. Sure. They're having a meeting on Friday, I believe.
Fascinating to me.
Instead of a big tower.
Oh, that's great.
So
Wonderful meeting
exciting.
you.
Likewise.
Yeah.
All right, thank you guys so much.
Yeah,
It was
it's-
fun. Welcome.
Oh, yeah.
Welcome. We call you Mr. Starling.
Starlink's a great service. That's how the Ukrainians fly their drones.
Seriously.
Seriously?
Yes.
Can you imagine? He's absolutely right about that.
So with that, do we need a motion to adjourn?
Oh, excuse me.
To
Do we
close
have a
the
motion to
meeting?
adjourn?
So moved.
Second? All those in favor? Aye.
All right, thank you.